If you've recently started a business and are thinking of bringing other people on board by way of shareholders, well, you might be wondering, do I need a shareholders agreement? Or how can I protect this arrangement between myself and these other shareholders, whether they be individuals, aka human beings, or corporations? In today's video, we're going to be discussing some of the main elements that go into a shareholders agreement so that you know what to look out for, what a shareholders agreement even is, what's the point of having one, and when is the best time to put one in place. My name is Pam Matani. I'm a business lawyer and the founder of Graphene Business Law, where our slogan is all business all the time, and we offer services virtually and throughout Ontario. So whether it's launching your business, helping you grow your business, or even concluding your business, we're here to help. Now, today's topic of shareholder agreements, of course, is one that we have a lot of experience with here at Graphene, and it's one that a lot of clients are interested in having in place, this type of agreement to, of course, protect their interests. Before we even begin, what is a shareholders agreement? What does it cover? Big picture. Shareholders agreement help describe how a company should be operated and the rights and responsibilities and obligations of the different persons involved in this company by way of holding shares. Important to note is that person legally can mean human being, and it can also mean corporation. Okay, so shareholders might not always be people with hands holding a piece of paper. Now, what is the benefit of having a shareholders agreement in place, and when should we have one? The best time to put such an agreement in place is when you are thinking to bring on your first shareholder. If you've decided to open your corporate structure up to bring in shareholders, whether it be for investment purposes or whatever reason you thought was best for you that needed that extra set of hands on deck, record it through a shareholders agreement as soon as you've decided to go that route. You can think of a scenario where if something goes wrong between the parties that are involved in an agreement, well, you can't exactly bring to court the document you wish you had in place at a certain date. You can only bring what you have. And if that's nothing, then you significantly jeopardize and negatively impact your position in a legal argument as against somebody when there is nothing in writing to govern the relationship you have between yourself and another shareholder. So the best time to get a shareholders agreement in place, just to summarize, is as soon as you bring somebody on board, but you talk to a lawyer even before that, right? If you've already brought somebody on board and you've been operating for some period of time, well, there could already be activities that have happened that could be to the detriment of you and your business. So again, this video is not legal advice. This video is educational so that when you do go talk to a lawyer, you know what to ask, you make better use of your money and your time with that lawyer. And of course, here at Graphene Business Law, like I mentioned, we are certainly here and able to help you with shareholders agreement and drafting strong agreements to protect you and your business interests. Now, what are some of the sections we see in shareholders agreements? First of all, there's even different kinds of shareholders agreements, including a kind called a unanimous shareholders agreement, okay? Of course, we're going to be seeing a section naming the parties, right? Officers and directors, which is the leadership of the corporation. And when you hear these terms, if you're a small shop or an entrepreneur starting out on your own, it's important to know that these are technical business and legal terms. It's not, don't take it as an intimidation factor. You know, we're not looking to appoint like the CEO of Coca-Cola here, but every business is going to have, if it gets to this stage, of putting the shareholders agreement in place, it's going to need to have officers and or directors identified. So that's a section. Another section, of course, and the crux of the agreement would be what kind of matters are you going to be voting on and what kind of vote is it going to take to make those matters passable and implementable in your business. For example, if one of the parties in your business on the leadership of your business is looking to enter into a contract, into an agreement with another company, they're thinking this would be really good to advance your business interest if you partner with someone else. Well, is that something you want to know about? Of course it is. This should be brought to a vote between the shareholders, and it's up to you what you want the passable standard of that vote to be. So if you have 4 shareholders, is it enough that 75% of them, also known as 3 out of 4, say yes to this initiative, or do you want everybody? Do you want what's called unanimous voting to take place every time that you have something as significant as a new contract in place, new loans being taken out, anything with significant impact to the finances of the business, not limited to finances though, but so many times when we're talking business, it's those dollars that help the business grow and get it to the next stage. So that's why so much of these agreements do focus on capital and whether positive in terms of cash injections or, like I mentioned, collaborations to the companies, or negative in the term of debts, including loans. Okay. What restrictions do you want on the transfer of shares? So you can imagine a scenario where, people come from all different backgrounds. They have all sort of different incentives to be involved in something. Somebody gets involved with your business, but they don't really want to be there. They just want that power, and they're thinking they're going to transfer these shares to a buddy of theirs. They're going to transfer them somewhere that you might not have wanted if you knew about this in the first place, but they're going to transfer them out as soon as they can, as soon as they want to. Well, what is your threshold for the transfer of shares? What kind of vote are you going to have in place there? Can anybody transfer their shares, any of the shareholders, just because they want to and they feel like it that morning, including potentially to a party that's detrimental to the core interest of you and your business? Or do you want procedures in place? You cannot transfer these shares under these conditions. If you pick somebody to transfer shares, we as current shareholders have what's called a right of first refusal. So you're the first one to say yay or nay to the purchase of the shares. And if you don't want them for whatever reason, well, you still get to say over the person that is picked to hold these shares. You should want that kind of power. This is your business that you've worked really hard for, and you have your special sauce, and you have your, whether it's intellectual property or special product or delivery of that product or service. It's you've worked really hard to have what you have in place, and just because you bring somebody in as a shareholder on day 1 and it's all smiles doesn't mean that the smiles are going to continue on day 2 or year 2 or year 5, right? We don't know when and if something bad will happen, but we do know that when you have this agreement in place, it makes it much less likely that something bad will happen, and if it does, it makes it much more likely that the result would be to your satisfaction because you can point to something. Okay. What another section, what could constitute default of the rights and obligations or the responsibilities of any of these party under these shares? So what would it take for somebody to do that's not okay with you and that gives you the right to either kick somebody out or have some repercussions placed on them or have them face some serious consequences for doing something that was not appropriate under, the roof of your business? What does that look like? What are your worst fears for this business? And how can we help you codify that in a way that's legally adherent and appropriate? Okay. And speaking of transfer of shares, by the way, another subcategory of that we see in these agreements, and that's necessary there because unfortunately it happens to people every day, and that's the transfer of shares upon death. What kind of terms do you want in place for if and when that day comes to be for one of your shareholders? So I'll leave this video there. Shareholder agreements are one of the key, most fundamental agreements you can put in place at the beginning of your business. Of course, if you have shareholders involved. And shareholders could look like a lot of things. There's passive shareholders that are coming on board just to invest. There's active shareholders that are actually partners in your business. And then we're looking at partnership agreements as well. And of course, we're very experienced with those agreements here at Graphene. Graphene Business Law, we can help you with all of these agreements that it takes to get your business off on the right footing. You can contact us anytime. Our website is graphenebusinesslaw.ca and our email is info@graphenebusinesslaw.ca. Again, we're able to deliver business law services virtually and throughout Ontario. I'll leave the video there. Thank you for watching.